when I received the invitation, I winced because I live on the other side of the world and I really wanted to come. I'm very grateful for the way that it has been made possible to be here, 24 hours flying, 10 hours timed as well. I don't have to explain this to you. And I feel very honored to do the inaugural lecture of a very exciting series of lectures, I'm sure. And I'm already now very curious about the questions, if not the comments that I will get after having spoken. So all this you have already seen. I am a lawyer and a philosopher. I work at a law faculty. I feel that it is very important that lawyers begin to really communicate and interact with computer scientists. And I do hope that at the end of this lecture, it is clear why. So this lecture is basically about what some people call legal tech, legal technology. And there are various responses within the law from lawyers to legal tech. One response is that artificial intelligence in the law is simply nonsense. That the law is something else, it's about human language, about text, so that this is entirely not feasible, or waste of time, and just like old-fashioned, old-school artificial intelligence, which was more about logic and argumentation by machines, that this new wave of artificial intelligence will just pass. Another way of looking at it, also within the community of lawyers, is to say, well, this is fantastic, because the way these machines will democratize the availability of legal services via all sorts of apps. You have a problem with whoever, your landlord or some other big company, and you just open your phone, you find the right app, and you get an estimate, a prediction of what your case, whether you would win a case after putting in some data. Another idea is that AI in law will solve many problems because our law currently is what I call text-driven. It's based on text. That text is naturally ambiguous, and that the enormous amounts of legal text, so binding legal text, legislation, policy to which government agencies have bound themselves, case law and doctrine, that the amount of text is so much, and especially when you got to international or transnational jurisdiction, the contradictions have come to such a point that without AI, we will simply drown. And the idea of one legal system where it is at some point clear which legal rules apply without AI is impossible. Well, I think one of the most sensible ways of looking at it is to say that AI in law will probably solve some problems and definitely create new ones. Sorry, it's as simple as that. Having said that, that's of course not the end of the story, but the beginning. Because everything is going to depend on how we develop this legal tech. And already the term "we" here raises a lot of questions, because who are we? Is that the lawyers? Is that the computer scientists? Is that consultants or policymakers? By whom? And maybe the most important question is, for whom? And that question is, of course, in part answered by the question, who is paying for this? To put it in machine learning terms, what are we optimizing for? So if we train algorithms on legal text, so we think that legal text is about meaning, about semantics, about reasoning, but in a machine learning contraption, legal text is just data that you're trying to correlate. And what you're asking the algorithm that you're trying to train to do is to optimize. But optimize is not an intransitive verb here. The question is, what are you optimizing for? What is your objective? And if you have no answer to that question, the machine will not learn anything. So this is the Allen's Hub for Technology, Law and Innovation. One of the questions here is, should we as lawyers understand how the technology of legal tech works? One way of answering that question is no, because we drive a car and we don't know how the engine works, and that works very well. Just try to imagine that you could only drive your car after taking an exam in how the engine works. We don't do that. Just for those of my generation, remember Pirsig's famous novel, The Art of Motorcycle Maintenance. I'm not going to go deep into that now, but it's a very interesting thing to look at in this respect. Now, we also go to the doctor and we sort of accept the diagnosis and the plans for treatment of the doctor. Should we first try to understand what that doctor studied for 6, 7, 8 years? Probably not, though doctors will probably experience their patients as coming in and saying, I have these six symptoms and I've Googled them and I think I have this. Now you tell me what I should do. Note that doctors generally diagnose people by treatment. So there was a time, undoubtedly not anymore, that you thought you go to the doctor, you tell him what's the problem, and then the doctor thinks about it, gets all this knowledge up in his head, maybe looks it up in a book, and then he knows what's wrong and he begins to treat you. But the reality has always been that a doctor has 6, 7, 8, or 10 potential diagnoses, or maybe none, and he's going to try something on you. And then when you come back, he will say, okay, this is excluded, but this may work. Okay, then it's probably that's how it works. But again, we expect that the doctor knows about it and we don't have to get involved. Now, actually, that means there is trust in the doctor's knowledge, trust in that the engine is built well. And we have to now ask the question whether we can trust legal technology. I'm going to talk about that, and I'm going to do that dealing with these subjects. Let's start with the subject of magic. So I'm going to start with a quote. We must not believe that democratic conditions automatically maintain themselves, or that they can be identified with fulfillment of prescriptions laid down in a constitution. Beliefs of this sort merely divert attention from what is going on, just as the patter of the prestidigitator enables him or her to do things that are not noticed by those whom he is engaged in fooling. For what is actually going on may be the formation of conditions that are hostile to any kind of democratic liberties. I'm especially charmed by the term prestidigitator. Of course, you know what that means. I didn't. I had to look it up. Does anybody know what it means? Yes. So this is about a magician. And it's interesting because there is a word digit, like in digital, and the word digit here simply refers to fingers, because digit is Latin for fingers. So this is about a magician that is trying to fool you by being very swift with her fingers. When I read this, I thought, wow, this is very, very topical about what is happening at this moment. It's actually a quote from John Dewey from 1939. John Dewey, the American pragmatist, who had many very interesting things to say about democracy. Now, a magician tries to lure people into believing things. And when you go to a magician, you want to be lured into things. The question is whether the use of legal tech does not invite a similar lure. So to think, okay, if we have this tech, we can predict judgments from court cases, then this will make our work easier. It may democratize things for people. And as long as I don't know how it works on the back end of the system, we're going to be very happy. I think that's a very dangerous way of going about things. And it is, for instance, one example of this lure is that some people, not necessarily on the side of computer science, but even within computer science, some people claim that there is a trade-off between interpretability of this software and accuracy. And that sort of suggests that as these systems become more difficult to understand what they're actually doing, what is the reasoning behind their output, they become more accurate. So the less you understand them, the more accurate they will be. So that sort of invites, let's not try to make them understandable, because that will downgrade their functionality. This is wrong for this simple reason. Sometimes it is true that while the accuracy goes up, the interpretability becomes more difficult. That is, if A, then B. When the accuracy goes up, the interpretability goes down. Turning this inside out is, of course, not true. The fact that the interpretability goes down does not imply that the accuracy goes up. That raises the question that if a developer of such technology says that she does not understand what the AI is doing, that raises the question what the accuracy actually means then. Can we then be sure that this is truly accuracy? Similarly, some people claim that blockchain, which is another type of legal tech, I will not be talking about it too much, but because it seems to rise in prominence, it is still very necessary to mention it. Some people claim that blockchain applications support trustless transactions. This is, of course, not true. What happens is that the trust in institutions, financial institutions, courts, or the state, is displaced in exchange for a trust in a technology that most people do not understand, or trust in the miners and the protocol developers, the people who are actually making it possible, or the people that write the code for smart contracts. Okay, so this is what I mean with the lure of magic. We don't need to understand the engine of our car to be able to drive. We don't need to study medical science to trust the doctor. So we don't have to understand legal tech to use it. In anthropology, the term magic refers to mistaken attribution of causality. So you do a rain dance and then it rains. There must be causality. This raises a certain fear and subservience, because you don't really understand how come that if you do this dance, that it rains. That raises the power of the priest who has said a rain dance must take place. Similarly, I would claim that we are now invited to believe that there is an arms race going up between China, the United States, Europe, Australia, and that is why we must now all share all our data, for instance, our behavioral data. Anthropologists have long treated non-state societies without the script as primitive. By now, we know that that is a very wrong characterization. So, such magic, attribution of causality, while we actually don't know what is happening, is also part of our own society. All societies that survive find ways of fact-checking. At some point when rain dancers keep on not accomplishing rain, something will happen and check this. And often, of course, rain dancers have many other functions that have nothing to do with the rain itself. To do this fact-checking and to call the priest or computer scientists or the board of a company that employs this kind of technology to account requires resilience, patience, and a serious effort, in this case especially of the lawyers themselves, to understand this technology before scaling it up to massive employment. And this is what we have actually also done in the case of the car and the doctor. It is because we have liability system in place because of the safety issues around cars and clearly all the safety issues around, for instance, the use of medication, medical research. Because of those liability systems, because of a lot of requirements, if you want to introduce medical drugs, medicine, that is why we trust this technology. At this moment, and that's why we can also afford to say, I don't need to know more about it as a user. At this moment, such liability systems are not in place with regard to these kind of technologies, also not regarding legal tech. Such a system to generate trust, so this is not only about liability, which is a private law issue, but also about administrative law, about imposing certain requirements, about the fact that those laws, both private law and public law, administrative law, have been decided by a democratic legislator. We call this the requirements of the rule of law: legality, auditability, contestability. Okay, I'm going to go briefly into a research project that I have just been awarded by the European Research Council. And the title of the research project is Counting as a Human Being in the Era of Computational Law. And when I wrote the application, one of the parts of the application, I started with this quote. It's a quote from 1963, by the way. And it says, it would be nice if all the data which sociologists require could be enumerated, because then we could run them through IBM machines and draw charts as the economists do, full stop. However, not everything that can be counted counts, and not everything that counts can be counted. This is extremely important. There are two meanings of count in this quote. The first is counting in the sense of computation, calculation. This is what computers are very good at. Now, basically, what the quote says, and what I say, is that some things are incomputable. This is also a term in mathematics and in computer science. From a computer science perspective, incomputability has something to do with moving from axioms to deductively drawing conclusions from that. And in computer science, there has been proof, mathematical proof by Daniel Wolpert, or David Wolpert, sorry, there are two Wolperts. Both start with D. I'm temporarily at a loss which one this is. So he formulated the mathematical no-lunch theorem. I want to connect that with the development of machine learning. If you do machine learning, that means you take data and you train an algorithm on that. We will come in a little bit more detail to that later. Now, what you want to do, what you like to do, is you want to make inferences from that data in order to predict new data. There is one thing that limits the ability of machine learning to achieve predictions, and that is the simple fact that you can only train on historical and present data. You cannot train an algorithm on future data. That sounds very obvious, but that is precisely what limits machine learning. So from the perspective of computer science, there are limits to what can be calculated and computed. This leads me to a provocative statement that the mathematical assumptions of machine learning are actually incorrect. And I'm going to explain that a little later. But they're very productive. So it's okay that they're incorrect, but they're very productive. As long as you keep in mind that they are not correct, they can do great work for us. Okay, so this is about incomputability from the perspective of machine learning, from computer science. But in the quote that not everything counts that can be counted, and not everything that counts that can be counted counts. This quote also talks about counting in another way. It talks about counting in the sense of to qualify as something, to matter. This has more to do with the very specific way that people interact. It's more about an anthropological perspective. I'm giving you a set of names here. I don't have time now to go deep into that, but basically you could say that the way we interact with each other determines how we cognize, how we know things. I'm going to give you, try and explain what these philosophers that I named here mean with this. Imagine that I talk to a small child. I think it's about a child of between 1 and 1.5 years old, a child that is learning to speak. And I tell this child, you are Charlotte and I am Mireille. That child is then going to say, you are Charlotte and I am Mireille. Because the child is repeating what I say. It is imitating me. And then I say, no, 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 no. You are Charlotte and I am Mireille. And the child will repeat again, you are Mireille and I am Charlotte. And then in the course of a few weeks, I think, the child will suddenly realize that she is you to me. And that decentering, that looking back at yourself from the perspective of another person, is what makes us human. This is a perspective that a computer does not take. It doesn't have to also. But it makes a computer a totally different thing, have a totally different existence than a person. It also means that when I say I, the constitution of the self, as we say, that we're not born as a self. We are developing into a self because we are being addressed by others. One of the systems that we have at the level of society to address people is the system of law. In that sense, law also co-constitutes us and our expectations. Now, this has as a consequence that the reception of Descartes' cogito, Descartes was the philosopher who said, I think, therefore I am, writing in Latin, cogito ergo sum, that the reception of this quite revolutionary statement is a bit lopsided, as some people would say, Descartes himself, his own statement, but let's not go into that. So we're on the verge of publishing a little volume under the title, Being Profiled, Cogitas ergo sum. So cogitas means, you think, therefore I am. So the constitution of the self, by how the self begins to anticipate that others see her. So what this basically says is that profiling as a technology, something that computers are doing with us all the time, because we are being profiled, we get better search results from the search engine that we use, for instance. This fact that how others profile me is not a new fact. It's not because we have computers that we're suddenly constituted by machines. This is something that is part of who we are as human beings. But so far, the way we relate to each other is based on human interaction and on norms that have been instituted by institutions, human institutions. Something changes when the anticipation that becomes very important for how we are targeted comes from these machines and not from other human beings. So one of the questions this book tries to answer is, to what extent is being profiled by machines similar to being profiled by other persons or by institutions such as the law? And to what extent is something changing because of the computational background of the systems that are targeting and profiling us? Now, so far, legal protection as we know it, legal remedies, being able to contest decisions from governments, etc., is basically protection between being overdetermined by how others target us. And especially because of the legality principle, rule of law, we are protected by being overdetermined by how the state sees us. And the question that I now want to ask is, what happens if the law, as a system that is based in natural language and in text, moves towards a system that is in part based on data-driven and code-driven legal tech? Very quickly, when I talk about data-driven legal tech, I'm talking about things like e-discovery, so using machine learning software to quickly do searches for facts all over the web or other parts of interconnected systems that I can reach. But I'm also talking about argumentation mining. So looking at large amounts of legal text, like what I said in the beginning, so that is statutes, treaties, legislation, case law, and doctrine, and trying to find similarities, their patterns, in such a way that I end up with relevant argumentation patterns in that text, so that when I have a particular case, I can do a search first for which legal texts are relevant and then for potential arguments. Finally, maybe the most interesting, maybe also the most dangerous type of artificial intelligence that is being developed now is the prediction of judgments. When talking about code-driven legal tech, I'm thinking basically of code-driven legislation, code-driven contracts, and code-driven decisions. As this is being discussed and developed at this moment, it is connected with the blockchain. So the idea is that instead of writing in natural language a contract, you translate the content into code. And you make that code self-executing. So let's think of a contract of sale. It means that I put, if I am the person who has to pay a price, I put that money on the blockchain and we agree on code that determines upon what sort of trigger the other party has performed its side of the contract. And when that trigger is given, the fund will automatically be transferred to that party. So we're talking about self-executing code. For contracts, with a simple example like that, I suppose it is clear what that means. But you could do the same thing with legislation or a level under that with regulation. So a regulatory body that has certain discretion develops a policy on that, could begin to write that policy into code that self-executes. The most simple example is, of course, tax law. So you get an income, and because of self-executing code, the tax is automatically deducted from that. And with every move that you make, the tax that is part of that is executed autonomically. Okay, I'm going to move back to artificial intelligence and try and explain briefly what is machine learning. Actually, I try never to use the term artificial intelligence because it means anything and everything. So let's talk about machine learning, which is what is now usually meant when people talk about artificial intelligence. I'm going to explain it with an example of A/B testing, and I do that with a reference to a website. So I am actually convinced that all the websites that you really like, that have a smooth user experience, very functional, at least that we experience as very functional, are continuously being A/B tested. What does that mean? You have one website, you call it version A. You make a very small change on that website. You change the color of a button or the position of a button, the position of text with regard to other elements of the site. But just one small change. You call that version of the website B. Of every 1,000 visitors that come to your website, 500 go to version A, 500 to version B. This is all software. It's not somebody that is actually looking at what these people do. And that software automatically calculates which of these two versions attract the most favorable behavior. That can be clickstream behavior, so which invite the type of clicks that you want. It can be simply purchasing behavior. So which of the visitors buy more, which version invites more preferred purchasing behavior. Now, as soon as you know which site has the better outcome, that is the site, which version, that is a version that becomes your new version A, and you continue this process. And you continue this process continuously, because it may be that you now find that changing the button into red will give more sales, but 3 days from now you will have to change the color again because all your competitors have found the same thing. So to distinguish yourself, you have to go to another color or do whatever else. This is about creativity also. So if this is done continuously, you could say that we are continuously being nudged into certain behaviors by these sites. And all this runs in the background. This is very interesting. So A/B testing is, of course, also used for advertising. We know that our online environment has one business model, and that is ad revenue. So if you want to optimize a website in terms of revenue, you will want to put content on that website that attracts more advertisements or higher bids for advertisements. So we are now surrounded by online environments that basically have ad-driven content. Now, my position is that all this micro-targeting, as it is usually called, does not really work because human behavior is far too complex and we're far too smart. From the perspective of computer science itself, you can see why it probably doesn't work. This is because there is an urge to move too fast to thinking that it works. To know whether something like that works, we're talking statistics, you need to look at the statistical relevance. And one of the problems is that because this is all moving very fast, there is a lure for the advertising intermediaries to do what is called p-hacking. And in this case, that means as soon as you have the significance statistically that you find favorable, you stop. That basically means it is methodologically completely unsound. But since nobody understands these systems, people are going to continue buying into this. Actually, Procter & Gamble in the beginning of 2017 decided to withdraw its entire budget from this sort of advertising. And 1 year later, beginning of this year, they said, well, it didn't cost us anything. Why am I telling you this as an introduction to going a little bit deeper into machine learning? I'm telling you this to make the point how important it is for lawyers not to make that same mistake. We do not want legal tech that is p-hacked. Very shortly, that is crappy machine learning. The definition of machine learning from one of the handbooks of machine learning, I love this definition. It doesn't say anything too much and nothing too little. Is a computer program is said to learn from experience E, in this case that is legal text, with respect to some class of tasks T, in this case, for instance, prediction of judgment, performance metric P, getting it right. If its performance at tasks T, as measured by T, based on experience E, improves. This is what machine learning is, nothing more complex than that. Basically, that means that in order to do good machine learning on a field like law, you have to depend on the domain expertise that is fed into the system. This is what computer scientists call ground truth. So the truth that is on the ground, the knowledge that the people, the professionals, the lawyers on the ground have. So we were talking about experience E, task T, performance metric P. How you choose them makes all the difference. And there are all kinds of trade-offs when you design the system. So the politics is in who gets to determine E, T, and P, because that makes all the difference. If you get to formulate the task, then you determine what this system optimizes for. The ethics is in how they are determined. For instance, are you optimizing the measurement of recidivism? I'm referring to the software that in many states in the United States is employed to determine parole decisions or sentencing decisions. Software is called Compass. Are you optimizing for trying to cut out racism? Or are you just optimizing on the most banal statistics? This is a whole discussion at this moment in the United States, outside the United States, which has triggered a whole discussion on what actually is fairness here from a statistical and computational point of view. But I want to immediately move on to the law. Law is about contestability. So how do we make legal tech contestable? How do we make sure that we can get our fingers behind it, see what it is actually doing, and make sense in criticizing it? So I always read that Compass wrongly decided that black people recidivize more often than white people. I always read that, and it's absolute nonsense. All the people involved in this debate agree that based on the data, black people recidivize more often. That is not the point in that discussion. The point is that the way the company that has the proprietary software to do this handled the statistics means that of all the people who do not recidivize, the error, the statistical error for black people is to their disadvantage, and the statistical error for white people is to their advantage. That's a very precise thing to say. And this is what Julie Angwin found out. Once again, the company who owns the software said Julie Angwin doesn't know anything about statistics. Because if black people recidivize more often generally, then that is the problem you end up with, full stop. But by now, a lot of computer scientists have said, no, that is not true. That depends on what you optimize for. You could train an algorithm to say, of all the people that will not recidivize, we want the same statistical error whether they're black or white. You can easily optimize for that. Now, to have an informed discussion, it is very important that lawyers do not say, oh, it's racist, because that's not enough. We have to go a step deeper. Let's quickly look at a paper that was written about the prediction of judgments of the European Court of Human Rights in Strasbourg. We see that the advertising model on this website is still in full swung. This is a screenshot, by the way. So here we see AI programming able to predict human rights trials with 79% accuracy. Now, this is very interesting. When you read this, you might think that this software has been used and is in use and continues to predict 79% of cases right. Now, we're going to look a bit deeper than that. So remember that you first have to decide your data. That's E, that's the experience. Computers can experience only one thing, and that's digital data. They cannot experience anything else. What data did the people who developed this software use? They used text extracted from published judgments. They said, they write in the beginning of their paper, we assume that that is a proxy for applications lodged with the court. Well, there's a lot to be said about that, because not everything gets published. Actually, they only used the cases that were in English. There's also a lot of cases in French that are not published in English. So here we already see we don't have all the relevant data. Why did they do that? Why not take all the text that is relevant? Well, simple. This is a matter of low-hanging fruit. You take the data that is easily available for you. That's a big problem, because then you must realize that certain conclusions that you come to are based on an assumption of which you already know that it's not correct. For scientific research, no problem. This is what any computer scientist will do, and that is how knowledge grows, etc., etc. But don't then suggest that you now know for sure that you got it right in 79% of the cases. That's absolutely not true. Based on these assumptions in this data, yes, but that's limited on all sides. Now, there is another thing. When you take the text of the published judgment as your input data, any lawyer knows that if a court is going to make a decision in which they quote the facts of that case, they're going to write down the facts in a way that is conducive to the outcome that they have decided. You don't have to be very smart to understand that. You don't even have to be a lawyer. But lawyers certainly know that, right? That means that your input data has in it already the result. It's not the facts of the case that you have looked at. It is the facts as selected and as rendered by the court after it has made up its mind. So you could say, we don't have to look at the 79% anymore because it's totally flawed. I'm not saying that. I'm not saying that. In terms of scientific research, this is very interesting. But if somebody now says, let's from now on build a little app, and then if you have a human rights problem, you just feed some data in the app and use this software, and then it says, oh, you will have a chance of 34% of 69.3% to get your case run. Very democratic. I hope even at this level of looking at the paper, you already see that that would be absolute nonsense and misleading the people who use the app. But let's go on a bit more. Cases that have been held inadmissible or have been struck out beforehand are not reported. So you cannot use that data, which entails that a text-based predictive analysis of these cases is not possible. Again, your experience is a reduction, it's restricted. And again, it's understandable to make this decision. Computer scientists are very practical people. You first try the low-hanging fruit, the published judgments. Again, the problem is these cases that are not reported, applications, would probably make a difference, which now remains invisible. Again, being pragmatic, the authors of the paper, the developers of the software, restricted themselves to cases related to Article 3, 6, and 8. That's the right against torture, privacy right, and the fair trial right. So 3 out of a lot of other rights. Why? Very practically, because they provided the most data to be scraped and sufficient cases for each, which is necessary, otherwise you can't run your statistics, right? Understandable. Problem? Well, here you are framing things. You are actually suggesting that cases are either Article 3 or Article 6 or Article 8. But if you have ever read a case of European Court of Human Rights, you will know that in the application, it will say this is a violation of Article 8, but also of Article 10, and may also be Article 14. And all the arguments are intertwined, and it is the court at some point that then decides we're only going to discuss this because this is clearly a violation, so we don't have to discuss the rest. So we are basically presenting conceptually linked terms, as independent variables. Ha, ha, ha. Is that wrong? No, it's very practical. You want to do research, fine. Should we then say 79% accuracy means that it's a very good tool? No. So we must distinguish between this is exploratory research, very interesting, but it doesn't confirm anything. You don't have the data for that here. Of course, the choice was for a publicly available database, low-hanging fruit. Okay, now, there are other decisions to be taken. I'm now going to go very swift, otherwise I will be keeping you here till 12 o'clock tonight. To do the statistics well, you want to have an equal amount of violation and non-violation cases. And you want to do a bit of labeling. So you want to take out certain words. So the text is the data, but we are going to take out the N and the of and the in and other terms that are repeated that you think are not really interesting. Okay, I'm not going to go into all these details, but they're on the slides, and I'm sure the slides will become available. You can then also look up the article. It's really very, very interesting article. Here's a table, all sorts of technical details. Now, one of the conclusions of the paper is that for the prediction, law has the lowest performance. Facts say the authors are more important than the law. And they go a bit further. They start to elaborate on that and they say, well, here we have a confirmation of legal realism. It's all about facts. It's not about law at all. This is nonsense. And actually, I hope I don't have to do the rest of this slide because I hope that I've been so clear that you already immediately see that this is nonsense. Actually, the authors in the beginning of their paper seem to indicate that themselves. The facts have been framed in a way that they fit with the outcome. So don't be surprised that the facts are determinate here. Actually, you don't have the facts. You only have what the court said. In a lot of the cases, there is no law section because if a case is declared inadmissible, some of the published cases are declared inadmissible, there will not be a law section. That means also here statistically, you can't go and say that the facts are the most important because in some of the cases there is no law section. Okay, now, okay, back. Finish. We have seen the amount of effort we, the lawyers, will have to make when somebody throws this in our face and says, look, I've asked lawyers, I've asked lawyers to make a prediction and I've compared it to this software system and this system does much better. So I hope I've given you some ammunition or at least skepsis to say, yeah, well, okay, interesting, but. Now, this is something we have to learn. So far, lawyers have been doing text-driven interpretation. So what does that mean? Well, normally a good lawyer does close reading. You go through the text, for instance, of a case, go through it very seriously, try to fetch all the reasonings connected with the doctrine that you're aware of, etc., etc. So we say that when we read cases, when we see legislation, that there must be integrity, there must be something like coherence. This is implied in one of the fundamental principles of the rule of law, treating like cases alike and unlike cases unlike to the extent of their unlikeness. Under the rule of law, legal certainty is not just a rigid way of always doing the same thing. It's not just logic. Legal certainty also opens space for contestation. That is due to the fact that interpretation at this moment is focused on text, that is human language, that is ambiguity. It is this ambiguity that at the same time makes it very important to establish legal certainty so that people have some idea how this text is going to be interpreted, how it will affect their lives. But at the same time, it opens a space of contestation and argumentation. This is very different for data-driven and code-driven law. Basically, I'm now referring to Franco Moretti, who works in the realm of the digital humanities, who said what these sort of systems do is remote reading. So we're used to close reading. Franco Moretti works in literary sciences, where people write doctorate theses on one paragraph in a famous canonical book. And that's all close reading. And he says with these new technologies, we can start doing remote reading. That means you put a system, put a whole lot of text into it, an amount of text that we, because of our bounded rationality, would never be able to all read. But the machine can read all that and then make inferences, do argumentation by them. This type of remote reading is usually done by natural language processing. The coherence that the algorithm is going to try and achieve is based on the approximation of a mathematical target function. So what a machine learning system actually does is it tries to calculate a relationship between input data, in this case legal text, and output data, in this case, for instance, violation yes or violation no. That relationship is a mathematical function, nothing more. It's not about an explanation, it's not about reasoning or meaning. It's nothing to do with it. It's a mathematical function. So there is an assumption with machine learning that our world, also our legal world, is basically ruled by mathematical functions. That's a very interesting assumption. I don't think any lawyer has ever assumed that. Or assumed that by getting hold of those mathematical functions, he will become a very good lawyer. But the point is, to the extent that we are going to delegate certain tasks, outsource certain tasks to these technologies, we must realize that it is based on this assumption, that there is a mathematical target function that the algorithm is trying to approximate. That means that here legal certainty is based on predictive accuracy or on the blockchain type of legal tech, but let's leave that apart now. Now, text-driven normativity has a specific relationship with legal protection. I've already said it, so I'll go quickly. Because of the ambiguity that is inherent in human language, the law is flexible, but not so flexible that its application becomes arbitrary. Lawyers, courts, judges are constrained. They can't just follow their whims. They're constrained by legal norms. That's at a very abstract level, but also by the fact that a higher court will impose its interpretation on them. So it's a complex set of interactions between legal texts and those who have to interpret them. So lawyers are used to first suspend their judgments, and they're used to the fact that the legal norms that are positive law constrain the space for their decision. Text-driven normativity is also what gives us practical and effective legal remedies. That's connected with the fact that there is the issue of interpretability that makes law uncertain, but also enables contestation and thereby forces us to make arguments. Data and code-driven normativity have a very different relationship to legal protection. Here, we are either freezing the future by making predictions and then basing decisions on that, or by using self-executing code. That means that the protection that lawyers can offer will have to be the contestation of the statistics or the contestation of the execution of self-executing code. That means that the idea of legal protection as we know it today, as we are trained as lawyers, will radically change. We will have to make sure that we have a good grip on statistics, that we can actually speak enough statistics to contest this, not by throwing name cards, but by really getting to the bottom. This is on the slide, so the slides will become available. It's very important. People talk a lot about algorithms. There's one algorithm that is trained in the course of machine learning, that is doing the learning. It's called a learner. Once the system has learned and the output is there, you can translate that output into another algorithm. That's a totally different type of algorithm. That's an if this then that algorithm. So after you have trained the learner, and the learner tells you that cases with these 4 characteristics always result in a violation, a judgment that says there is a violation. You have trained the algorithm, this is what it comes out with. Then you could develop another algorithm that says all cases that have these 4 characteristics result in a violation. It's a very different type of algorithm. And I'm making that point because if you don't understand the difference, then it becomes very hard to contest anything or to argue against everything. I'm going to finish by making a distinction between legal protection by design and legal by design. If you use legal tech, whether the data-driven or the code-driven variation, you could use it in such a way that you basically enforce compliance. Some people say, like Roger Brownsworth, and me, that this is no longer law. So if you reorganize legislation or contracts in a way where non-compliance is ruled out technically, then you're talking about technical management, not about law. You're talking about administration. When I talk about legal protection by design, what I'm basically saying is what I said before. We cannot continue to think of legal protection in the same way as we have always done. If we do that, we have no tools to protect ourselves, but the people also to whom the law will be applied, against being overdetermined. So legal protection by design would mean that if you develop and employ legal technology, you have to embed in the design of that technology the legal protection. So just writing it down in the technology of the word, technology of text, is not enough. You will have to embed those norms at the level of the design. This will have to be based on democratic legitimization, it may be more important to discuss in Parliament and to get people involved about how we design these new legal tech, these new norms, that may be more important than all other regulation and legislation that we make, because all the legislation, if it is implemented via legal tech, will suffer if we do not get this well. It becomes preconditional. But the most important thing is that we build contestation into the design of these systems. Yes, and I had wonderful examples of the GDPR here that I will give you, and I will close with saying that legal tech is, of course, not magic. It does not deserve blind trust. It is certainly not like a car engine or like medical science. Law shapes checks and balances that enable such trust. And that means that we lawyers will have to develop a new legal hermeneutics way of interpreting the law to read the output of legal technology.
So this is an opportunity for a few very short questions. There are two roving microphones. Please state your name and your short question with the emphasis on the word question. I promise to listen to the full conversation version over drinks. So, yes, starting.
Thank you very much. Philip Hargy. I like your analysis, but I don't think there's anything novel in this sense. When you tender expert evidence to a court, the courts are very careful to demand that you expose with full transparency the thought processes, the assumptions, the logic that you've brought to bear in expressing your view. Isn't it simply the case that when you encode and you've embodied assumptions, you need to make them transparent and you need to expose for analysis and validation what's behind the code that you've written?
Yeah, I think that's a very good question. It regards the difference between an explanation and a justification. Yeah. So, maybe you've noticed, maybe you've not noticed, but there is an entire discussion that has erupted around a part of the GDPR, where some people say that Article 22 prohibits automated decisions, so decisions either data-driven or code-driven that are fully automated, and that to the extent that an exception applies, there are 3 exceptions to this prohibition, that people have a right to an explanation. There's a whole literature now about that, where computer scientists and lawyers are fighting with each other whether there is such a right to an explanation. Part of this is in the recitals, so it makes it a bit extra interesting. Whether there is such a right to explanation, and if so, what it means. I have been writing that we must be careful not to mistake the explanation of a decision with the justification. This means that if a court comes to a decision, I'm not going to ask that court, can you please tell me whether you decided this because you had a row with your wife this morning? I want to know all about it because I think that has influenced you. That's not how we do law. We say to the court that you had a row with your wife, I don't care, and I certainly don't want to know. You are restrained by a set of reasons that are part of the law, and that is how you can tell me that you justify your explanation. Yeah? So it seems to be that you're saying, well, as long as we stick to that it's all about justification, then we are fine. But the question here is, the minute for instance, Compass is used in the United States to support decisions for which, in this case, courts have a certain discretion. The software that is used is proprietary, so it is not possible to look into the software and see exactly how it works. And the question is also whether that would just be an explanation. So if there is discretion, the court can use reasons and make that decision. And the explanation of how exactly the software came to its conclusion is not part of that justification at this moment. That's one part of an answer. Another part is that this idea that for a decision reasons have to be given may at some point be limited to things that really come to human courts. And a lot of other decisions may be made in the forefront. Just try to imagine that what we now have in healthcare, that we develop systems of triage. That means that before you're allowed to take something to court, you first have to go through some sort of online application which makes an estimation of your chances. Actually, there are already proposals for something like that out there. That means that in a few cases you can go to court and ask for your reasoning, but all the other cases are going to decide on other grounds. And the grounds are mathematical, as I said. So one of the problems is that you are so right that it is very easy to say, well, that's not how the law operates. The problem is that the law is probably going to operate differently unless we engage with these technologies and can pinpoint what reasoning is going to be necessary by whom. And for that, we will really need to understand how these explanations work at the level of the design of the system.
Hi, John Selby, Macquarie University. We had a chat in July quite a bit at a course, so I'll resist the 4 questions that I had and maybe just ask one. With the decisions made by code that you were talking about, I'm interested to see whether your research projects are looking at the way in which bankruptcy law can reverse transactions, and that if you make something immutable, whether bankruptcy law and bankruptcy judges will simply say, sorry. Yeah,
yes, and then we enter...
And what you do.
Yeah, so then we enter... Yeah, very good question. Then we enter the problem that self-executing code on a blockchain can't be stopped unless... It can, of course, be stopped. You can, if you, depending on whether it's a public, non-permissioned blockchain or a private permissioned, if it's a public non-permissioned blockchain, that means you have to convince about 30,000 people, actually nodes, to change their way of doing things. And since this is not a centralized system, you actually cannot do that. So people who are... I've mostly talked about artificial intelligence. People who are now working on the blockchain end will say, well, the jurisdiction of law, as we know it, this text-driven stuff, will simply be in competition with a new type of jurisdiction between inverted commas that will just go its own way, and there is nothing you can do. So you can make a court order, but the code will run on. So huge and very interesting problems here, again.
Well, given the time, we'll wrap up here. I would, however, first of all, like to thank Professor Mireille Hildebrand for a fabulous talk. It was exactly what we wanted in our inaugural annual lecture. It both challenged what everybody thinks while aligning completely with what I think, and indeed representative of the kind of work we are trying to do here in the Hub. I should add, in terms of the point about lawyers understanding the statistics, that from next year we have a new data science and decisions law undergrad combined degree. So we are trying to get there eventually, and they will eventually come. So please thank Professor Hildebrand.